Hi, Jason Kohlmeyer, Rosengren Kohlmeyer Law Office, Mankato, Minnesota. Today's question is, do you write prenuptial agreements? What if we have a prenup? Can I write my own? Three questions are all kind of the same. Let me talk about what a prenup, or technically it's called an antinuptial agreement in the law. It's the same thing. What that means is that you sit down and you talk to your spouse and decide, if we get divorced in the future, what's going to happen, both possibly to the children. Usually it's more with the money. Believe it or not, it's not that common to do a prenup in Minnesota. And the general reason is unless we're talking significant sums of money and complexities, you don't need to. And what I mean by that is that if you're coming into the house with, let's say, coming to the marriage with, let's say, a $500,000 house that's already paid for, the law puts a marker there, and that would already be considered non-marital property. And so then if you get divorced, let's say 3 years later, you already had the house free and clear, it's now worth $700,000. Generally speaking, you're going to walk away with the house no matter what. So there are certainly some times to do it. The best time is if there's non-marital, premarital property involving significant sums of money. Businesses are one of the bigger reasons to do a prenuptial agreement. So there are some reasons to do it. They have to be fair, so no matter what you write, if you try and do your own, which I would strongly advise you not to, prenups are one of the most heavily litigated areas in family law. And just about every prenup has the ability to be pierced or redlined, which means that the judge doesn't have to follow it. It's fairly common to beat a prenup, not all the time. And so you really don't want to do it yourself. You don't want to order one online for 50 bucks. Prenups are expensive. They're expensive because they take a lot of time to do. And so there's a lot that goes into a prenup. A couple of the key components that you have to do. You have to, number one, have full disclosure of assets, meaning that you have to, in writing, give each husband and wife a list of the assets so you know what you're talking about. Number two, it has to be fair. And the last major component is it must be signed no more than 24 hours, or no sooner than 24 hours before the marriage. And so that means if you're getting married on Saturday morning at 10 a.m., you can't have your soon-to-be wife sign it at 8:30. It's not going to fly. There's some other technical components too, such as witnesses and that sort of a thing. But the big thing is that you have to sign it 24 hours before. Long answer to a pretty simple question about prenups. I hope that helped. I'm Jason Kohlmeyer. Thanks for the question.